And I think we have a great panel. The discussion is going to focus on the barriers to release, which include, of course, the parole system and how is compassionate release used, issues of low risk and high risk as words, and what is the potential for change in this. We're going to, the people who are on this panel are Marc, who's the executive director of the Sentencing Project, Farid Mujahid, who's the lead organizer of the Release Aging People in Prison RAPP campaign, Edward Hammock, who's the former chairman of the New York State Parole Board, and Jamie Fellner, who's the senior advisor of the U.S. program of Human Rights Watch. We're going to follow the same protocol that was in the first panel. Each person will speak for 5 minutes. I will use my watch and my waving arms to try to make sure that we hold it to that time. And then we're going to have a discussion of questions that I've gotten from the panelists to ask them. And then probably 15 or 20 minutes before the end, we'll open it up for questions from all of you. We're going to start with Jamie Fellner.
It's on. 2 years ago, I was at Fishkill visiting a unit for aging prisoners. These were prisoners who were in some form or another, had dementia. They were playing bingo. And some of them were so far gone they needed staff to help them put the markers on the cards. And that was really, for me, symbolizes the sort of tragedy and the lack of any rationale for keeping people past a certain point in prison. I'd like to use my 5 minutes to ask you to think about what are the purposes of punishment. Because when we go forward, when we talk to people, I think it's important to go back to first principles. Holding people accountable for a crime, especially a crime that has injured someone in a very real and direct way, is indispensable to a criminal justice system. But committing a crime or being convicted of a crime isn't licensed for whatever punishment the state wants to impose. Now, it's true we don't have flogging anymore, and we don't do drawing and quartering, but we do routinely and consistently and continually impose punishments that are vastly disproportionate to the actual conduct, to the nature of the culpability of the individual and the crime that was committed. It's most obvious to think about that in terms of drug crimes. Who's been harmed against their will if I sell you drugs that you want? There may be a problem with drug abuse, but is it a crime that warrants 10, 20, 30 life without parole sentences? Crimes of violence get a little more tricky. If somebody killed my daughter, first of all, I'd kill them. But if they, what kind of sentence is fair and appropriate? And we, when we speak to people, have to understand the grief and rage and endless sorrow of people who've lost loved ones. But that still doesn't answer the question of how long is long enough. It's very different in Europe, for example. People grieve just as much when their loved ones are killed, but they don't impose life without parole sentences. So let's think for just 2 minutes about what are the purposes of punishment and how do we decide what's a proportionate sentence. You have retribution. Someone should be punished because they've done a terrible thing. 2, incapacitation. We want to protect public safety by keeping you locked up so you can't do it again. Deterrence. We want to send a message to others, you better not do this or you'll be punished. And rehabilitation. Now, all of those may factor in and should factor into the original sentence that's given, but the calculation of how those purposes of punishment change as someone becomes old and infirm. If somebody can't even put the numbers on a bingo card, are they really a threat to society? If somebody is now so infirm they can't get out of bed without assistance, are they really likely to be if they had a career as a robber before, are they really likely to go, into a bank, roll in, and roll out? Not likely. So the purpose of incapacitation changes. And retribution becomes, rehabilitation obviously it isn't an issue, and deterrence, I'm sorry, I don't think if you tell a 30-year-old you're going to get out after 20 years or 30 years makes much of a difference in terms of deterrence, and all the literature says that. So we're back to retribution. How much is enough? And I think we need to engage with that conversation directly, not by minimizing the crimes that were done, but by saying human rights requires respect for the human dignity of every person, and including people who have raped, maimed, murdered, or whatever else they've done. And at some point, respect for human dignity means a chance to reintegrate with society, a chance to make amends, a chance to have the change in you recognized, whether that change was when you moved from being 20 years old to 40-year-old, or even if you've committed a crime, and unfortunately there are many crimes committed by 50, 60, and 70-year-olds, you still can change. And that change has to be honored and recognized. And that, to me, is the problem with, and we'll talk later about the parole system. It doesn't want to honor the person in prison and doesn't want to honor their capacity for change and the fact that they've changed. Thank you.
Thank you. Marc Maurer is going to address the growth in long sentences and look at the situation from a national perspective.
Thank you. First, my thanks to the organizers. It's such an important issue, and it's wonderful to get this kind of attention. I've been doing this work for a while. I started in the state of Michigan back in the 1970s. At the time, I spent a lot of time with lifers in prison, and the situation in that state, and I think many others as well at the time, was that if you were sentenced to life with the possibility of parole, it was not unusual to get out in 15 or 18 years if things went pretty well in prison. 15 or 18 years. Even people sentenced to life without parole occasionally could get out as well through a gubernatorial commutation. And on the day that you were sentenced in court, the judge knew that a life sentence might mean 15 or 18 years. The prosecutor, defense attorney, and the person receiving the sentence, of course, knew that as well. And there was no big dispute about it. Today in Michigan, the parole board basically says our policy is life means life. That's not what the judge said on the day that person was sentenced. The parole board is now saying life means life. And this is just one slice of what the change has been in policy and practice over these last several decades. If you look at criminal justice broadly today, we're all feeling sort of cautiously optimistic. The prison populations are starting to go down a little bit. There's more rational discussion about alternative kinds of measures to deal with public safety and the like, and that's all good stuff. At the same time, unless we address life and long-term prison issues, I think in many ways we're kidding ourselves that we can have any kind of substantial impact on the prison population, because even as the overall population is starting to decline, the lifer population continues to grow. The numbers, I think, are pretty shocking. Of the people in state or federal prison today, 1 in 9 is serving a life sentence, and of those, nearly a third are serving life without parole. So we have 160,000 people nationally serving life sentences, 49,000 of those people serving life without parole. Many of you know of those life without parole, about 2,500 of them committed their crimes when they were juveniles and received the sentence of life without parole. Research done around the world looking at how is life without parole imposed for juveniles in other nations finds that there are exactly 0 other known cases of juveniles receiving life without parole in any nation. So that leaves, one of two conclusions. Either we have the 2,500 worst kids in the entire world here in the United States, or somehow we are much more punitive than all other nations in this regard. Fortunately, as you know, the Supreme Court in a couple of significant decisions is cutting back somewhat on the imposition of life without parole for juveniles. So where does this come from? We'll talk more about it in the discussion, I think. I think a number of factors contributed to this. Part of it is the general tough on crime movement, and let's get tough on the most serious offenders in particular. Changes, as we've seen in Michigan and many other states, where executives and administrators of parole boards and the like have become exceedingly cautious, and this goes up to the White House today. Each succeeding administration in recent years has been more and more cautious about using the powers of pardons and commutations. And you can count on just a couple of hands the number of times that they take advantage of this. We had a comment from the audience, a previous panel, how life without parole becomes the alternative to the death penalty that abolitionist campaigns take on, and that's absolutely true. It's a very difficult strategic and political issue for us to deal with, but I think we have to talk about it. And finally, I think it often comes from what I think is a fairly artificial distinction between people labeled violent offenders and people labeled nonviolent offenders, and how we separate them out and how that works out in terms of parole considerations and the like. And again, I think unless we take a comprehensive view, in addition to reasons of compassion and cost and the like, if we really want to have an impact on mass incarceration, we absolutely need to address these issues. So I think it's terrific that we're convened here today to talk about this, and I look forward to engaging on that. Thanks.
Thank you. We're going to be able to follow up on the issues that have been raised so far, but let's move now to Farid, who is going to speak about his own personal experience and the work that he's doing in creating the RAPP campaign.
Right. Thank you, Kathy. Good afternoon, everyone. I'd like to first thank all of you for your presence here today. Excuse me. Said I'd like to thank all of you for your presence here today and showing interest in this issue. Being that we are discussing one of the major issues we are discussing is the broken parole system, I'd like to illustrate just how broken that system is by giving you some insight into it, my experience with the parole board. I don't want to cover a lot of things that you can find by reading in the booklet, but if you look there, you'll find that I served 33 years. Actually, in 1978, I was sentenced to a sentence of 15 years to life. It was for the attempt murder of a police officer. And I'll just add that the officer wasn't harmed. He claimed he heard me snap the trigger of a gun in his direction, plainclothes officer. In any event, I received a sentence of 15 years to life after going to trial and being found guilty. And I think I should point out that that sentence of 15 years to life was the least amount that the court could impose on me. Normally, when you're found guilty of an attempted crime, it's downsized one degree, and a person would receive a lesser sentence. For instance, if that had been an attempt on a civilian, I wouldn't been able to receive more than 25 years as the maximum. The most 12 and a half to 25. But in any event, because it was a police officer, I received 15 years to life. I could have received 25 to life if the court had decided to impose the maximum. In any event, I entered the state system, and I made a lot of major improvements insofar as rehabilitation before that 15-year period. Most of those things that you are reading that I accomplished in that bio, all of that happened before that 15-year was up. When I appeared before my first parole board in 1993, I had actually achieved all of those things, such as 4 college degrees, creating rehabilitative programs that still exist in the system, and quite a few other things. I appeared before that board and was denied. I was denied because of the nature of my crime. And I wasn't given any direction as what I could do to improve my chances for parole. That happened every 2 years for 9 more boards. I actually went to 10 boards every 2 years and heard the same thing until that 10th board where I was released. That situation, I realized, was something that was happening pretty much across the board. I saw it happening to almost everyone who was serving a sentence for the type of crime that I was sentenced for. it had become rare for a person to be released who was sentenced for a homicide or a crime involving violence. Now, I heard earlier that someone framed the system as tripartite, the courts, the prisons, and parole, and that each one of those entities has a certain responsibility. But there's a fourth one that is very important for us to integrate if we're going to make a change with this thing, and that fourth one is the public. These entities do not operate in a vacuum. They are supposed to be there to serve the public. And because of sometimes our weak response to these type of policies being implemented, a lot of the policies and practices are passed down to us instead of us commanding from below going up what we want. And I think once we internalize that, then we'll see major changes in parole practice. And I think, yeah.
Thank you. Edward Hammock is going to describe the parole system and how it actually works and doesn't work. So I'm going to turn it over to Mr. Hammock.
Thank you, Kathy. Good afternoon to all who've come. And as everyone has said, we're happy you did come. Farid ends up talking about public involvement. And, you know, our concept in the state of New York is you elect people to the electorate in order for them to represent you. So your way of giving input to them is through your assemblyman and your senator and trying to get them to do the things you ought to do. But if you don't have some organized thoughts about what needs to be done, it's very hard for you to pressurize them to go in the directions that you as a public think they ought to go. It's hard to do the parole board today or in the past in 5 minutes, so I'm going to try to do a little bit for you. Some of the things that I'm going to say have already been mentioned. Farid says we should have 4 people adding in the communities, and we do have 3. The way our system's supposed to operate, you read the correction law, you read the penal law, you read the criminal procedure law, and you see that we're supposed to have the prosecutors have their day to figure out who to indict, and under our Constitution, they make that decision unfettered. They can decide who to indict and for what. And then when there is a conviction, the sentencing responsibility seems to be in the court, but it's a shared responsibility because in every case where there's a guilty plea, generally it is the prosecutor who decides on what the sentence is going to be. The assumption is they've investigated the case, so they know what it's really worth, and they're making a firm recommendation to the court. The court's in a position to accept or reject the prosecutor's recommendation. Usually they accept. When I say usually, over 90% of the cases. So you really have a lot of DA sentencing in the state of New York, but it's coming from somebody who presumably knows the case. And then when the judge imposes a sentence, either after a plea agreement or after trial, when the judge has full discretion, it's his or her responsibility to make an appropriate sentence, given the criminality, prior criminal history, and any other relevant facts. And now it goes to corrections. And the job of corrections, as they like to say themselves, is care, custody, and control. They're carrying out the sentence in that they're holding on to the offender until such time as he is released. There is some limited releasing authority that corrections has as a result of some legislation that came down before Governor Pataki left, but it's not very often used, and it's almost not used at all today by corrections. So pretty much the release of offenders, those who have determinate sentences, is after they've served 6/7 of their sentences, and those who are subject to old law indeterminate sentences, those who are subject to current law indeterminate sentences, the nonviolence, and those who are, well, I guess the drug offenders get in there a little bit too, depending upon old law sentences going along with their current determinate sentences. Just going out? You still hear me? Oh, okay. And then the board has the lifers, and we're getting as many lifers as we can get from our juvenile offenders who become lifers That is, they stay a lot longer than was ever anticipated by the legislature that they would, and the regular life is like Farid was when he came into the system. What's the parole board supposed to do? It's supposed to be a continuum. We're supposed to have a system of criminal justice, and it goes from prosecution to sentencing to incarceration to release. The presumption was that what the parole board would be looking at principally would be, what did a man do while he was in prison? If you don't think that's so, read the law. That's what it says. Somebody commented in the last panel, I came in late on that, but I heard him saying something about the seriousness of the offense. And there was a gentleman who asked a question, and he was concerned about getting denied release because of the seriousness of the offense. And what the panelists did say is that when that consideration was put into the law, it was at a time when the majority of sentences, minimum sentences, were being set by the parole board. And it was in there because the parole board, in order to set a minimum sentence, clearly had to take into account the seriousness of the offense. Otherwise, how could they arrive at a determination? It was interesting that the parole board then did have some assistance. They had their guidelines at the time, which were presumed to help them to formulate what would be an appropriate sentence. And they were doing that by looking at how they themselves had treated similar offenders in the past, so that there would be a basis for this determination. The parole board lost the minimum set function some years back. Now all judges set minimum sentences and indeterminate sentences, and those sentences define the period of time that the person is not eligible for parole. Parole eligibility comes at the end of the minimum term, except for merit time and some other special programs. And so the parole board doesn't get a look at somebody until he's basically or she's basically served their minimum term. What are they supposed to do at that time? Are they supposed to use seriousness of the offense as a way to keep people in? Not really. If you look at where seriousness of the offense is mentioned in the legislation, it is one of 15 other factors. There are a load of factors that the board is supposed to take into account. The one the board has used and gotten us into a lather about is almost exclusively seriousness of the offense. What's interesting in most of the cases where that is used, there is nothing so particularly serious about the offense that would warrant, in the judgment of anybody rational, that the time in prison be increased over the minimum sentence if, in fact, the individual had used his or her time in prison the way all of us would hope that they would. Farid said he had everything done by the time he had completed his minimum, and it continued to be done after he went back for board after board after board. When you go to the courts and say, well, how can a board keep on using seriousness of the offense? You have the board saying, well, we don't know that that's the only thing that they considered. Just because the board didn't say it considered this other factor or that other factor as being determinative doesn't mean that they didn't do it. So you don't see it on there, you can't argue it, and you can accuse them of not doing it, but you don't have the proof. So you lose on your Article 78, and you go back and continue to do your time. Does it sound like I got a little thing going with the judges? You're darn right I do, because the judges have laid back and have stayed away from the parole board. And there's some justification for it, because they feel these guys are the experts. Governor appointed them, they're there, they must know what they're doing. Why am I going to step in and overrule them? So they back off. Now, more and more judges are beginning to pay attention, and they're coming after the parole board. But each one who does is suffering his own consequences. Some are being supported in their communities for re-election, and some are not. Some people are happy with the decisions that they're making, and some are not. And of course, when they make a decision, it's subject to review at the appellate division, which sometimes goes along and sometimes doesn't. Where we're at today with our Board of Parole, they seem to be a darn rudderless ship. What I can tell from comments that have been made by the former chairperson, Andrea Evans, at the Black and Puerto Rican Caucus last month, she said every parole board member makes up his or her own mind. They decide what they want to do. I mean, is that a good thing? Is that what we want from our parole board? Or do we want a board to have some kind of overall consistent pattern of behavior that we can come to rely on so that we have a yardstick to measure their decisions against? I think we should have that. Clearly, we do not. And unless and until we do something in that regard, I think we're going to continue to have the mess that we've got now.
Thank you. So I would like to call in Farid to talk about the issue of, we understand that the parole board has adopted a risk assessment instrument called COMPAS. What does this mean? Is it used? What do you think about that as a way of moving away from each individual parole commissioner deciding on their own?
As some of you may know, recently there's been a big struggle over this risk assessment instrument that the parole board supposed to be using and purports to be using. In 2011, March 2011, the legislator passed they passed a bill saying that that the parole board has to incorporate risk and needs assessments in their decision-making process. And so 2 years passed until recently, until there was quite a bit uproar over them not doing that, that they floated something that they are alleging incorporates risk and needs in this decision-making process. What they floated was 12 factors. They included 2 more, and they pretty much buried risk and needs into those 12 factors so that, exactly as Mr. Hammock said, that the courts can't tell exactly what played a role in their decision-making process. And so there was a big uproar in the community. There was organized effort to file objections and comments to what they were floating. They had to put it, they had to file this with the Secretary of State, and they had to allow for the public to comment on these regulations that they was proposing. And what happened was, I asked the person responsible for maintaining comments to regulations, exactly how that process petered out. And he told me that normally there are 30 to 60 comments filed when the regulations are being proposed. And then in our case, there was probably 400 or 450 comments filed. And that the vast majority of them, more than 80%, contested the regulations that they were proposing. And this gets back to my point that they should be responsible to the public. If the public says that the regulations that they want to institute are not sufficient for what was commanded by the legislator, they need to go back and redo that whole process. Thank you.
Can I?
Yes.
Yeah. I can't speak specifically to just the New York process, but I've talked and reviewed a lot of parole processes across the country in connection with medical parole. Most states, not all, but most states have something called a compassionate release, medical parole, something that is supposed to take into account age and infirmity. And what's interesting in whether it goes to a parole board, whether it's a decision made by the department director, whether it's a decision made by the governor, the nature of the crime usually trumps any other consideration. So one of the things, and that partly is a response to the public, it's partly a response to DAs. They work hard to get somebody convicted who's done a terrible crime, and now they don't want to see him released, even if that person poses absolutely no risk to anybody anymore. Victims associations often oppose parole for anybody, again, regardless of their medical condition or age, because that's what they do. One of the models I want to throw out and for people to think about, because it's partly a legislative responsibility and partly the decision maker's responsibility, is when there is an indeterminate sentence. The first, let's say 15 to life in your case, the first 15 years is the retribution. It is the punishment you receive because you've committed this crime. The decisions after that should be based solely on public safety. This is the way it is in some countries in Europe. 15 years is the punishment tariff. The rest is public safety. And then how do we ensure that those public safety decisions are in fact made based on legitimate concerns of public safety and not just politics and pandering again? You have to put the burden of proof on the decision maker to explain with specific criteria why this person remains a public safety risk. And the burden should become harder and harder as the person has spent longer and longer time in prison, assuming good conduct in prison, because otherwise there'd be some evidence that there might be a risk.
Thank you. Marc Miller, you had talked about the role that even people who are advocates, justice reform advocates, play in exacerbating this situation. Can you talk a little bit about that?
Sure. You know, I think a concern I have, and I think many of my colleagues, that, you know, as we see we are sort of making some progress in justice reform in recent years, it's not unusual to hear reform organizations or individuals talk about, you know, well, let's try to get the low-level drug offenders out of prison so we can keep enough room in prison for the violent offenders who we want to keep behind bars. And, you know, it's very appealing in some ways politically to make that argument, right? And it plays into a lot of assumptions people have about the differences between kinds of crimes people commit and their risk potential and things like that. And at its extremes, this was a couple of years ago, as you know, California has a 3 strikes and you're out policy, as half the states do, but California's was by far the most extreme because your third strike, your third felony could be any felony on the books in the state. And so there are cases that went to the Supreme Court unsuccessfully where one man was doing 25 to life for stealing golf clubs. Another man was doing 50 to life for stealing videotapes. This is what the law had brought. So there was a campaign started to scale back the breadth of the law, and basically that your third strike would have to be a serious or violent offense as described in the statute, similar to the first 2 strikes. Now, we could discuss whether the 3 strikes policy, even for violent and serious offenses, is a good idea, but that was the idea, to scale that back. So a campaign was started, and they had a fair amount of funding and all, and the first couple of times the spokesperson for the campaign, whoever that was, came out and had some press conferences and events to launch the campaign, you know, attended by lots of the press and things like that. And he came out and was making this basic argument about the trade-offs and use of prison space, and he said, you know, what the voters were originally voting for and didn't realize it at the time in the 3 strikes policy, they didn't want the so-called lower level people locked up, but they wanted to keep room in prison for the truly most violent monsters to be locked up forever. These are friends of ours who are doing this kind of stuff. Truly most violent monsters is what we're talking about here. Now, there's all sorts of problems with this, you know, not the least of which is if we're ever going to see a broader discussion about reform and public safety and incarceration, just demonizing people, stereotyping, feeding into the worst possible imagery that many people in the public already share. Yes, you can win some battles in the short run, but in the long run, we're just doing the work of the most hardened politicians who are more than happy to use that kind of rhetoric and the like. So, you know, I think there's no shortage of stories, there's no shortage of data, there's no shortage of testimonials from corrections people and others who can make the argument along with us about, you know, you can't just define people by the worst thing they've ever done in their lives. It's not a good correction strategy, it's not a good fiscal strategy, and certainly not compassionate either.
Thank you. I think that building on this conversation is the words low risk and high risk. And I'm wondering if somebody would like to comment on the use of those words and the kind of the irony in how those words are used. Okay.
Yes. Addressing that subject, I'd like to say that something that Jazz said earlier when he spoke really resonated with me. And it was really that point about the discussion seeming to accept the fact that there are people with life without parole in the system. And that is a fact now, but it doesn't need to be engraved in stone. We need to not accept that as something that's going to always be. When we talk about risk, public safety, even those people at some point need to be reviewed. And if they are not a public safety, then there needs to be consideration given to releasing them. The slogan of RAPP is, if the risk is low, let them go. And so we apply that across the board. It doesn't matter how much time a person has. If a person has pretty much served a sufficient amount of time, the person is aged, we know that they present no risk to public, then they should be given consideration for release.
Can I?
Yes.
Yeah. Part of the problem with risk is there is no way of reducing or calculating the risk any of us pose. We don't know if we did a risk assessment of everyone in here how we would come out. So, but there has been this notion of no risk is acceptable. And every time there has been someone on parole, like in Connecticut, when somebody commits a crime when they're on parole, and we all remember the Willie Horton story, although that was furlough, everybody shuts down. Politicians don't want to risk, and the officials who work for them in the executive branch don't want to accept any risk. So partly it's, we have to start becoming a little more comfortable with that there's always going to be some risk because human beings are mysterious and can't just be numbers added up. Two, how do we assess risk? One of the dangers is that the factors that are often used to assess risk vary by gender, by race, by class, by education. We see in New York, for example, when the New York Criminal Justice Agency is assessing risk for not returning to court. Did my thing just go? There are factors like whether you have how long you've lived in your residence. Well, some people move around a lot. So we have to be very careful that we don't end up substituting code words that are for race, particularly, poverty, gender, and call those, objective risk factors. The final thing I wanted to say about risk is people who commit the most violent crimes tend to have the lowest recidivism. In other words, they're the lowest risk. A woman who murders her abusive spouse has a very low risk of recidivism. Somebody who at age 20 kills somebody, at age 40 has a very low risk of recidivism. And yet that data doesn't seem to still factor into the so-called risk assessments that are going on in parole boards and other places.
Let me just add on, because the former commissioner is here. What Jamie just said is absolutely true. You can look at DOCCS now, statistics on those who are convicted of most serious crimes receive the longest indeterminate sentences, and they have the lowest risk, and it's a real low risk. They beat out every other crime category consistently over the years, and there is no basis for an expectation that that's ever going to change. So it's not promoted in the overall society. Organizations like the not COBA, what is it? The cops, whatever they are. Not the cops. They're never going to go for it. But that's something they need to be hit with, because these guys that they want to keep in forever, and they think that the point and purpose of a parole board is to carry out their wishes, which wishes are not supported by the system that we have. When we get a system that says you can keep on punishing people or incarcerating them endlessly, then we can follow that law. But we don't have that law. These people are subject to release. And the thing that's so disappointing is that the parole board doesn't stand up for what their legal rights are, or their legal obligations are, to go ahead and release those people. And then let the police officer, the PO, which one is it? Police officers, POBA, police officers, PBA, damn it. The Patrolmen's Benevolent Association. Now I got it. Okay, and the Detectives Endowment is no better. And the cops have a lobby, and somebody's got to stand up against them. Why? Because we want to fight them? Because we hate cops? No way. They're just wrong. Somebody needs to tell it to them, educate them, and get them to understand that there's a point in time where the sentences have to come to an end. That their view that they can keep on coming out of the woodwork every 2 years when the board deigns to see an individual again and push for his denial, that's not good public justice. That's not good public policy. They've got to come into the 21st century with us.
Thank you.
Let me just add, I'm all for the 21st century myself. I think Jamie's absolutely correct. All sorts of, problems with risk instruments that, not very well hidden, sometimes race, gender bias built into it, and the like. At the same time, it's a complicated issue. There's some people who would argue we should get rid of these risk assessment instruments. They're inherently going to have disproportionate effect on certain groups and all that. If we do get rid of risk assessment instruments, we shouldn't kid ourselves into thinking the problem has disappeared because, as I think our parole board former member could tell us, we have human beings on the parole board and, they may not say it, but I assume they're assessing risk in their own mind every time they see somebody coming up for a parole review. Now, some of them may be doing it on a scientific basis from literature they've read, some of them are probably doing it from a gut feeling, but there's every bit as much danger of very discriminatory risk assessment assessments being made just by the individuals on the board. So in part it's a question of, do you want this risk assessment being done publicly, hopefully scientifically, how much weight does it carry, but it's going to be in the room regardless, and we should just figure out, what's the most reasonable way to take it into account that doesn't produce, counterproductive effects.
Well, I think, you want to say?
I just want to say this. During the course of our work, the reason I promote risk assessments is that I'm engaged with the lifers behind the walls who are being hit numerous times by the parole board. And we have been collecting their risk assessment, and almost to the man, these people have low risk scores. Mm-hmm. And so that's why I promote it. Mm-hmm. I want the parole board in New York to respect these instruments that they are using to determine how much risk a person poses to make their release decision.
I want to clarify, I'm not saying that there shouldn't be risk assessment instruments. I just think we need to be cautious and that there are other factors that can't be captured in those instruments. But I think the bigger question is, how do we ensure accountability by parole members for their decisions? There's something valuable in having representatives of the public making these decisions. I don't think we want to get that away and just give it to, quote, experts. But they're not accountable. The transcripts aren't public. They don't have to explain their decisions. They don't have the burden. The legislature has not put on them the burden of sort of a presumption, which I'd like to see the presumption shifted so that after somebody's served the minimum time, there has to be very articulable, strong reasons why there's a decision that somebody continues to pose a risk. At the moment, they don't have to do that. They just vote.
So I would like to ask, going back to, I think, the original issue that you raised, Jamie, which is, since we have been living at a time when punishment has dominated, not just the criminal justice system, but other institutions of our society, what will make the shift possible? How does that shift happen? And who are the constituencies that might be interested in letting people with long sentences out of prison? And how do we raise the issues that they may be considering? And that's for any of you.
One of the things that Jazz said earlier that I somewhat disagree with is this whole thing about people considered about numbers. We're going to need those people if we're going to win this war. Those who are willing to work with us because of budget issues, that's a very important ingredient that we're going to need.
Well, I would add, in addition to the cost numbers, and at Human Rights Watch we sort of wrestle with this because sometimes cost counts so much more than human rights, so it's always a difficult thing. But one of the things we've seen in the last, Marc, you can help me remember, is it 5, is it 10 years? My memory's going, I'm going to be in one of those facilities soon. But is the engagement of the religious right on the right side of this issue. For many years, organized religion, many of the organized evangelical religions were very supportive of very punitive policies. And we're seeing a real shift in that, which is also coupled, at least in DC, I don't know how much at state bases, with people who are conservative, Republican, Tea Party, whatever, they don't like big government. And if there's nothing that exemplifies big, unaccountable government, it's the criminal justice system and it's the prison systems. So there's an interesting kind of dialogue that's taking place. It's still very new between across the party aisles, right and left. In fact, some of the Democrats are there are standing in the way more than others. Let's remember Senator Schumer for one. I'll call out a name. But I think that's a very promising thing. It's no longer name calling so much as to see how shared interests can be served by reducing rates of incarceration.
Mark.
Can I just say, all right, getting back to right where we are here in New York, going back to the Compass risk assessment, going back to the legislation that Farid mentioned, and the proposed regulations written up by Terry Tracy, who's counsel to the Board of Parole, wherein he wants to take, and looks like he's getting a little help, but he wants to take that risk assessment and fold it in with all the pre-existing factors that the board is to consider. So it, again, could be buried like they do everything else. The real reason they don't want to parole them is because they don't want to see their name in the Daily Post or the Daily News that I released so-and-so, well, son of Sam, how's that? That I released him. They don't want to read that. And that means that they're not going to take any criticism from the police officers or anybody else in the overall community. But most recently, the appellate division in the third department, that's the one up in Albany, construed whether or not the board could get away with their written procedures in support of this notion of taking into account how somebody does in prison. And they say, yeah, they can. So I did see somebody in this illustrious group of people who are trying to make things better sent me a copy of a letter that had been signed off on by the assemblyman who's in charge of the Corrections Committee of the New York State Assembly. And he was writing to Terry Tracy about his position on these written procedures. And he said, our intent, because the appellate division said there was no specific intent mentioned by the legislature that this notion of looking into risk had to be separate and apart from everything else. So he wrote a letter to Terry Tracy saying, if we didn't make it clear to you the first time around, we're coming back to make it clear to you again. Now, I hope he really meant that. And for us, in terms of getting back to that fourth group that Farid was talking about, we have got to keep Dan O'Donnell, I believe his name is, Dan O'Donnell, not keep his feet to the fire, but keep his head pointed in the direction in which we want to go. Because I would hope the parole board would fix itself. I think the prospects of that are guarded, limited at best. So if we have to go to the legislature, then we should go to the legislature. That's their function anyway. And if you've got somebody like Dan O'Donnell who says, I'm prepared to do something, let's make sure he doesn't forget his preparation.
Mark, do you want to speak nationally also on
Sure.
these
Well, just
issues?
briefly, I think it's the messenger as much as the message in terms of how we can shift the policy and all that. I mean, I think collectively we have a pretty good sense of what the arguments are. We know how the numbers work out. We know, how people turn their lives around and all that. But, who are the voices that are getting this out? And, yes, we're starting to see a greater variety of voices from the religious right, from just the right-wing people in general on criminal justice policy. I think also there are many people in corrections. Some of them are able to speak publicly, some less so. You saw probably was several weeks ago, there was an op-ed in the Times. The Commissioner of Corrections in Colorado was writing about solitary confinement, and he basically said, I'm the commissioner, we have a lot of people in solitary, I should find out what it is. So he had himself locked up for 20 hours in solitary and wrote about it, I think in very moving ways. The following week he testified in Congress about why their attempts to limit the use of solitary as much as possible and to reconsider what their goals were and reconsider how you might, when you need it, and because you have no other choice, but short of that, not to impose it. And, he has credibility because he works in corrections, and people are going to hear him in different ways than they may, some of us in the room or so. So I think our job is to find those voices, keep making the arguments, but to really spread the ways that the story is being told too.
Thank you. I'll take one more comment. I'd like to ask Jamie, what is the role of the human rights context, as opposed to the constitutional, U.S. constitutional context. How do you think about the role of that in this process?
Well, the U.S. Constitution, the courts have interpreted it in ways that make it extremely difficult to challenge the length of sentences that are imposed. There is jurisprudence there, but it gets applied in ways that don't work at all. Also, so the human rights framework starts with the notion of dignity, and it considers prison should be a punishment of last resort. There are many other ways to punish people consistent with their dignity and consistent with their right to be free of cruel, inhuman, and degrading treatment, besides long prison terms. Given that the courts don't seem to be a helpful vehicle, I think it is helpful to incorporate human rights language into the movement for reduced incarceration. It's not something you can use in the courts. It's not justiciable. You can't go into court and say my human right to a decent sentence has been violated. The same way you won't get anywhere if you say my right to a proportionate sentence under the U.S. Constitution. You won't get anywhere. But I think it offers a way of reminding ourselves that we're dealing with human beings, that conviction of a crime, as I said before, is not licensed to commit for any sanction possible, and that legislators are obliged to uphold the human rights of all people, just as much as Commissioner Fisher was obliged to uphold their human rights. The United States has signed treaties that put obligations on all and responsibilities on all public officials. Most state legislatures, I would warrant, here in New York and elsewhere, have no idea that they have human rights obligations. But I think reminding them and putting forward practical, sensible, and rights-respecting alternatives to the current system will bear fruit over time. That's the optimistic vision.
Thank you. So at this point, we'd like to open this up to people, those of you that are in the audience, and we have a good, we have 18 minutes according to the clock, so yes. You?
Okay, thank you. My name is Nakichi Taifa with the Open Society Foundation for the Washington Policy Office. Marshal Eddie Conway, a former member of the Black Panther Party, convicted for the killing of a police officer, despite proclaiming his innocence for the past 40 or so years, walked out of prison earlier this month as a result of a Maryland Court of Appeals a decision which basically has opened up the prison doors to people in the state of Maryland convicted of crimes before 1980 based on faulty jury instructions. He's one of dozens recently released, perhaps a couple of hundred more to come to be released as well. These are people who are not convicted of nonviolent crimes, but convicted of murder, rape, etc. University of Maryland Law School has been working with these cases and helping with the reentry of these long-held prisoners who are coming up now. My question is, my comment and question is, I think that there's really fertile ground to look at this population that are walking out of prison right now, convicted of violent crimes, fertile ground in terms of the whole issue of risk that we spoke of earlier, the whole question in terms of is there a danger, to the community? This is anecdotal evidence that's going on right here, right now, that I think can be used to, with RAPP, Mujahid, with the organization that you have formed, to try to have some evidence that it's not a danger to society, there is not a risk to public safety, and that these people need to be given a second chance.
Yes, I'll say something briefly. Yes, as I said earlier, our slogan is, if the risk is low, let them go. And yeah, I'm aware of Marshal Eddie Conway's release. We pretty much circulated that to the people inside also to give them some encouragement. That's about it.
My question builds on Nikichi's, because I look around here, and I think if you asked everyone who had served time in prison to stand up, a lot of people would. And I'm not just talking about role models for public safety, which, by the way, the campaign to release people who are at low risk of recidivism is a public safety campaign because it allows resources. This is where the human rights, the social justice, everything comes together. Resources could be used for education. Resources could be used for community centers, et cetera. The things that we know create society and community instead of prison. Okay, so what would you speak to? This isn't exactly about the challenge. This is more about the benefit, whatever we call it, cost benefits analysis I hear from some of my friends, of the role that formerly incarcerated people are playing in offering solutions to the prison, the crisis of over-incarceration, the crisis of prison injustice. And I think, you know, I work with Farid and Kathy, and I think we see it every day in our practice. I saw Mr. Hammock waving to Mr. Hayden, and I know they recognize each other. Every place we go, the former parole people recognize they're the people who came before them. And what is the role that people are playing besides standing as the face on the issue of we're not threats, to creating a different kind of thinking about how do we solve these problems of crime, damage to communities, and healing.
Is the question clear? I think the question is, we tend to emphasize the infirm nature of people that are aging, and thereby saying that there is no danger. But there's the other side, which is many people that come home are people who can make a major contribution to their families and their communities. And even if they are infirm, sometimes they can, just like the elderly in general in our society can. So how do we integrate these?
I don't know about the integration, but you know, as she suggests, if those who had previously been incarcerated stood up, you know, it'd be quite a few people. But there's a lot of guys and girls who are not here who have had the same experience. You know, it's amazing that you can live in a city like the city of New York and have no concept of how many people have had the prison experience. And we're on the subway with them, the bus with them, sometimes sharing a cab with them. Or we're getting served by them, we're serving them. They're all over the place. The numbers are very, very large. So it's, we have an uneducated public because we don't have a vehicle to educate them. You know, if the news, the Post I don't even read, so I can't tell you anything about them. But the news and the New York Times, if they get a story that they can run with, they do. But it doesn't seem to have any continuity. When they carry a story on somebody who is wrongfully convicted and he or she gets released from prison, it is maybe a 1-2 day story, because the last one was Phil Smallman, who was not an outstanding assistant DA in Brooklyn, but he managed to get it together as a defense lawyer, and he worked with this guy, and just recently, a week or two ago, got him out of prison after a whole bunch of years. Those, you know, when I was at Parole, the little bit of thing that we did do, we had a mayor named Koch, and Koch wanted us to get off 40th Street where the Parole building is. A lot of people who've gone there don't want to see it there either. But they wanted us to get off 40th Street, and he claimed because we needed to have a better community in Midtown Manhattan. So we were notified by some of his staff that they wanted us to clear out. So I was kind of frisky in those days and not too smart and politically inastute. So I took on Koch, you know, out there by myself. I don't know where the governor was. He was probably hiding. But in any event, I told him, and we had access to the editorial boards. We had a parole officer who developed access to the editorial board at the Post, the News, and the Times. And they would give us time whenever we wanted it. And so we took the time to go in and say to Koch, look, we're not bringing criminals to 40th Street. That's where they live. They're already in the community. You want to get rid of them, I don't know how you're going to do it. They got citizens' rights. You can't do that. We're bringing to the community law enforcement officers. The parole officers don't live in the area of 40th Street. Most of them don't live in Manhattan. They're coming and packing. Why? Trying to keep the community safe. We're adding to law enforcement in the community. Well, now go down to 40th Street between 8th and 9th, and guess what? Koch is gone. God rest his soul. But the parole office is still there.
Yes. A lot of people to fill in. Yeah.
My question has to do with gender disparity and the nature of juvenile girls entering the criminal justice system. And then in their 30s and 40s becoming the largest population
Yes.
Can I just ask for clarification? Do you mean they're the largest? Women are not the largest population in prison. It's growing, but you have to remember that if you go from 1 to 2, that's 100% increase. So because of the war on drugs primarily, women, the rate of increase in women behind bars has increased, but it's still a relatively small percentage of the population, both in New York and in prisons across the country. I just wanted to clarify that.
Actually, the largest growing population is the elderly. Since 1981, a human rights report calculates that from 1981 to about 15 years from now, 16 years, 2030, the elderly population would have grown by 4,400%.
I'll give you just some New York numbers, though. And you may have already done this, and I wasn't here, but at the moment in 2009, there were 22 prisoners in New York aged 70 and over who still had 20 more years to serve on their sentence before their earliest release date, i.e. they'd be in their 90s. I think we also have to acknowledge when we're thinking about the aging or the elderly in prison that the number of, quote, older people, they use 55 and older. I find 55 to be early middle age myself, but in the prison world it's considered to be moving on up there. But it's growing. 25% of the admissions for violent crimes, 25% of the admissions of people 55 and over in the most recent data were for violent crimes. So we both need to understand the problems of long sentences, and we need to understand the problem that the people committing crimes are also aging for lots of reasons. I don't think anybody in here would think that Bernie Madoff, who was considerably on in years when he committed his crime, should just get a free pass because of his age. But we do need to think creatively about, going back to that core question, how much time is enough, and are there other forms of punishment that can be used besides prison, especially for people who, for example, even if you think someone hasn't served enough time, but they're now so infirm that they're bedridden, house arrest is a form of punishment, and it protects public safety. I mean, we just need to start opening up the dialogue as to what can be done. I'm not saying house arrest for Bernie Madoff because his house would be rather extravagant. But.
All right, we just have a few more minutes.
Yeah. There's something that seems to be missing here. This whole question, as it's been posed and answered, has been coming from a punishment paradigm, as if it's the only one. I think we need to go back to the very inception. What do we want from a person who has committed a crime? And how are we going to approach that? We seem to think that punishment is the only way to doing that. That's not the only way of doing that. When a person commits a crime, the first thing we need to do, what do we want this person to be? We don't want him to commit any more crimes? No. Well, how we treat this person should be, treat this person in a way that when it's over, he will not commit any more crimes. That's altogether different from punishing him. I mean, the whole country is on this punishment scheme. We do it with our children. We don't tell our children, don't do this. We smack them on the hand as if that's the only way of doing it. We have to move beyond the punishment paradigm. We have to look at this. We want to reform people. We want to change their cognitive thinking and their behavioral responses. That's what we're about, and that's what we should be moving toward, not punishing him. Punishment doesn't achieve that.
So I want to push back on risk assessment. You tell me why I'm wrong. Why I'm wrong about this. So, I mean, first of all, I think, it's going to be very easy, as you said, to have some variable in there that's correlated with race. And so, essentially, now you're sort of systematically making decisions that are sort of racially biased. And then when I say this, the response is, well, the alternative is so much worse. maybe, okay, it's for, well, not everyone would maybe be taking, I mean, humans can, they're not going to be systematically making racial decisions, but why can't the alternative be, well, let's make this parole hearing look a little bit more like a judicial hearing. Let's get lawyers in there, let's get the public in there, let's get the decisions written up. Also, I don't care if you don't like what the New York Post writes about you. Appoint people to those positions who make decisions on the basis of conviction. I mean, this is what judges do, have a right to appeal these written decisions. Just make the whole thing look more judicial. Why is risk assessment, which is sort of very much different than that, or, you know, because we don't have risk in judicial proceedings, why is that not the alternative? Why is there such a sort of acceptance of risk assessment tool, especially given the fact that I really, you know, I don't see how you design a risk assessment tool that gets around this issue that Jamie has raised.
Well, let me just say this about the North Point. I don't know who they are, but they're from New England somewhere, and they have the risk assessment New York is using. They've used it in some other states, and obviously, when they got the contract, I guess those states said that it had gone well. It may have some biases in it, but that doesn't seem to be our issue of concern in New York at this time. The concept that we thought was coming is that instead of the parole board concentrating on the nature of the offense and how serious it was or was not, they would be looking more at what happened from the time the guy got to corrections to the point where he had an opportunity to meet with the parole board. And the guys do, like Farid did, they go after what's available. They go after the programs that seem to be appropriate for them. They go after training programs that would be helpful to them in making decisions about what they're going to do when they get out. They go into programs that may enrich them in some ways, even parenting programs they have available to them. Whatever is available in corrections, these guys will take. But if you go to Otisville, where they have a high incidence of lifers who get to know each other quite well as they go through parole board after parole board, these guys are getting low risk on the risk assessment instrument. So they're saying, how can I go to the board where their risk assessment instrument says I represent a low risk, and they're saying that I the member of the parole board find, that there's a reasonable probability that if I am released, I cannot live and remain at liberty without violating the law, and that my release would be incompatible with the welfare. So we then, the lawyer's side, when we do our Article 78, we say to the judge, look at what these people did on the parole board. What is the basis for the decision that they've made? They're making a prediction of future criminality. Based on what? Based on the seriousness of the offense? Based on the fact that he's already done the time assigned to him by the judge? How do you project that he's going to commit another crime? And if he has no prior criminal history, you already got nothing. Or if he has 5 misdemeanors that don't amount to anything, you still got nothing. Or if you have a low felony that he committed 3 years before he caught the big one, who cares about that at this point? So there really isn't any basis that they have for the decision that they make. You go into court and the judges say, well, we don't know that they really didn't give it consideration. Or they say the risk assessment is just another factor to be looked at, and if the board didn't consider that important enough, that's up to them. And Farid mentioned early on in one of his comments, and the courts have let the board off the hook on this too, when they deny someone release, they don't have to tell them anything that they could or should do to put them in a better position to get released when they come back after the 2 years.
I believe in California, if I'm not mistaken, Marc, you might know, in California now you have to tell the person if you're denying them. You have to tell them what they have to do so that the next time they come up, which is part of the way of, pushing on the parole process. You can't just deny it because you don't like the person or you don't like their crime. You have to articulate why, and you have to say what specifically. Okay, take an anger management course. Now, many people have already taken all the courses, and that becomes a problem. But it goes back again to the board here is not accountable. It doesn't have to explain itself. The legislature has not provided clear guidance as to what it's supposed to do, and its decisions, the criteria for its decisions aren't public.
Just quickly,
Let me just go on. Just hold, Jazz, do me a favor, just hold it. Let me just do this. I just want, well, I'm going first.
Well, you just go for a minute. Marc, if you could go.
we'll be quick.
Okay. I give up, I surrender.
Okay. No, well, just quickly respond. First of all, in terms of racial bias that goes into risk assessment, we're not the only people that know about this potential and this problem and all that. So, I mean, I think without sounding too idealistic, I think there's work going on, there's advocacy going on and all that. So, it's a contested issue out there. I guess secondly, yes, I don't have a problem having lawyers and witnesses, in the room and parole hearings and all that, but I think it's not the same as in the courtroom. The courtroom, we're trying to determine guilt or innocence, and we have the law that we're trying to look at and all. I mean, here, the parole board is looking at, yes, behavior in prison, accomplishments in prison, but, they're taking into account risk one way or another anyway. That's part of parole. Is this person ready to be released to the community? So I think there are some differences there. I mean, it's hardly an ideal system today, but.
Do you think it should be public, that parole hearings should be public?
I don't know.
I got to let the panelists, then you and Hammock are going to add.
I need the panel for my question.
No, you're going to have the panel. You're just going to be the last one.
I think that we're actually done. I just got one more.
Oh, I get the last one again? Wow, that's exciting. Sorry, Jazz, you lost it. But no,
I got a critical question.
as opposed to mine, right?
No, the issue here has been the parole board. And we act like they have a permanent place in the structure of the criminal justice system. Why can't that parole board be a community-based parole board with stakeholders in the community instead of these the people that they have sitting on these parole boards that don't even come from the communities where the problem first started?
Okay.
Right? The community should be, all parole boards should be community-based parole boards.
All right, thank you. There was somebody?
There still is, but
We have a critical question in the third row.
the other critical question.
And this is,
All right, and it certainly actually dovetails Jazz to a degree. We're talking about a system that everyone is convinced is broken. We have a trend that's rethinking criminal justice. Is it time to start talking about the value of a parole board at all? I mean, are judges less likely to give arduous sentences now because we're spending too much money? Maybe we just do determinate sentences again and start looking at what the numbers will look like.
so I'm going to.
I'm just wondering about that.
Yeah, I mean, that's a question,
Can I?
well, I'm not sure. No.
I think we have a limited time for lunch, and we want to have everyone back here on time to start our third panel. Also, by the way, on your way out, please do sign a petition by the Release of Aging People in Prison campaign, RAPP. They have a table outside. Please join me in thanking our panelists.
Terminating short.